thank you very much for keeping your time. I'm sure that all would agree that building trust between regulators, clinicians and the public is most important, is fundamental in having a well-functional healthcare system. Next we have Dr. Sunil Abhyaratna, Senior Attorney of Law at Law, to speak to us on regulating technology in healthcare. Dr. Abhyaratna.
Good morning. Thank you very much for introducing me. This is a centenary celebration of your organization. And once again, thank you very much to invite me to share my knowledge and the contribution from legal profession for the betterment of your profession. Ladies and gentlemen, I will not discuss main regulations relevant to your profession. I will briefly make my contribution, especially on the required regulation in future under the development of ICT sector. Technology is developing, we can't stop it. The day by day scientists are going for new technology. Information and communication technology is one branch of technology. Technology integration in healthcare is a revolution as far as patient care, medical research and operational efficiencies are concerned. From electronic health records to telemedicine and artificial intelligence diagnostic, technology plays a critical role in modern healthcare. However, this rapid advancement also brings challenges related to regulation, safety, privacy, and ethical consideration. Effective regulation is essential to ensure that technology enhances healthcare delivery without compromising patient safety or privacy. So what are the key areas as far as regulation in the health sector is concerned? Firstly, data privacy and security will play a vital role. Regulations like the General Data Protection Regulation, we call this a GDPR in European Union, even and the Health Insurance Portability and Accountability Act in the United States provide standards for the protection of personal health information. Compliance with these standards is crucial for healthcare providers using technology to manage patient data. In the meantime, cybersecurity also will play a vital role in this mission. As healthcare systems become more digital, the risk of cyber attacks increases. Regulations must enforce robust cybersecurity measures to protect sensitive health information from breaches. The Sri Lanka's Personal Data Protection Act, it's a brand new Personal Data Protection Act in Sri Lanka, enacted in 2022, Act number 9, marks a significant advancement in the country's legal framework regarding data privacy. This law aims to safeguard personal data while establishing clear guidance for its collection, processing, and storage. The medical profession, which handles sensitive personal information, is particularly impacted by these regulations. What are the key provisions under our brand new Act? Consent and data subject rights are very important under the Act. The Personal Data Protection Act emphasizes the importance of obtaining explicit permission from individuals before collecting their personal data. Patients have the right to access, rectify, and request the deletion of their data, which is crucial in healthcare settings. The law mandates that personal data must be processed fairly, lawfully, and transparently. Data minimization is emphasized, meaning healthcare providers should only collect data necessary for specific purposes. Medical data is classified as sensitive personal data, requiring additional safeguards. The law restricts processing such information unless specific conditions are met, such as necessity for medical purposes or with explicit consent. Healthcare institutions are required to appoint data protection officers, this is mandatory under this Act, to oversee compliance with the Personal Data Protection Act, ensuring proper management of patient data and adherence to privacy standards. This Act mandates that organizations report data breaches to the Data Protection Authority and affected individuals promptly, enhancing accountability and transparency. So let's see what are the implications for the medical profession under this. Healthcare providers must navigate the complexities of the Personal Data Protection Act, ensuring that their data handling practices align with legal requirements. This includes updating policies, training staff, and implementing robust data security measures. By adhering to the Act, medical professionals can enhance patient trust. Patients are more likely to share sensitive information with providers who demonstrate a commitment to protecting their privacy. With the rise of telemedicine, the Act affects how healthcare providers collect and manage data remotely. Compliance with data protection standards is essential, particularly when handling patient information online. Non-compliance with the Act can lead to significant legal repercussions and financial penalties. Medical institutions must invest in compliance strategies to mitigate these risks. As far as this development of this law is concerned, the personal data protection law in Sri Lanka represents a crucial step towards enhancing data privacy and security, particularly in the medical field. By prioritizing patient rights and establishing clear guidelines for data management, the Act seeks to foster a culture of trust and accountability in healthcare. As the medical profession adapts to these regulations, ongoing education and vigilance will be essential to navigate the evolving landscape of data protection in healthcare. Under the development of technology, next area that we have to regularize is medical device regulation. Regulatory bodies such as the United States Food and Drug Administration and Medicines and Healthcare Products Regulatory Agency in the United Kingdom oversee the approval of medical devices, ensuring they meet safety and efficacy standards before being used in clinical settings. Continuous monitoring of medical devices after approval is essential to identify any adverse effects or safety issues that may arise during actual use. Licensing and credentiality regarding telemedicine and regulations must address the licensing of healthcare providers who offers them telemedicine services, ensuring they meet the necessary qualifications and standards regardless of where the patient is located. Clear guidelines on reimbursement for telehealth services are needed to encourage adoption while ensuring that providers are compensated fairly for their services. Under development of artificial intelligence, we call this as machine learning mechanism as well, that AI algorithms used in diagnostic and treatment decisions must undergo rigorous validation to ensure their accuracy and reliability. Regulatory framework must evolve to evaluate and certify these technologies. Regulations should require that AI systems provide transparent reasoning for their recommendations, allowing healthcare professionals to understand and trust the technology. Interoperability standards are also important under the development of AI era. Regulations should promote interoperability among different electronic health record system to ensure seamless data exchange, which is vital for coordinated patient care. Regulations can encourage software developers to prioritize user experience, minimize clinician burnout, and ensure that technology enhances rather than hinders patient care. The rapid pace of technological advancement often outstrips regulatory processes, creating a gap where new technologies may be used without adequate oversight. Regulators must strike a balance between fostering innovation and ensuring patient safety. Overregulation can advancement, while under-regulation may lead to safety risks. Healthcare technology often crosses borders, leading to challenges in harmonizing regulations across different countries and regions. This inconsistency can complicate compliance for global companies. As technology increasing influence healthcare decisions, ethical considerations regarding algorithmic bias, patient consent, and the role of technology in clinical decision making must be addressed. So considering all these matters, we can conclude in this manner: the regulating technology in healthcare is a complex but essential task that requires collaboration among regulators, healthcare providers, technology developers, and patients. Effective regulation should promote innovation while ensuring patient safety, privacy, and ethical standards. As technology continues to evolve, regulatory frameworks must adapt to address emerging challenges, fostering a healthcare environment that leverage technology to improve patient outcomes while safeguarding public trust. At the moment in Sri Lanka, there are 6 pieces of legislation relevant to the ICT sector, starting from the Computer Crime Act in 2006, the Evidence Special Provisions Act, to give facilities to accommodate electronic evidence before court, Act number 14 of 1995. And then we have Electronic Transactions Act. It's important to maintain electronic records, electronic documents, and any communication in electronic form in Sri Lanka. We brought an amendment to this act after ratifying UN Convention on International Electronic Contracts. In the meantime, we have Personal Data Protection Act, just now I addressed on that, Act number 9 of 2022. And recently, our lawmakers introduced Online Safety Act, number 9 of 2024. Very soon we will get Cyber Security Act. As citizens, we may be medical professionals, legal professionals, or any other professionals. We are citizens of this country, so we are subject to these laws, brand new laws, because as I indicated to you earlier, technology is developing, it's relevant to all these professions. In the meantime, legal impact on these new technologies is also important for the betterment of our lives. Thank you very much.
Thank you very much, Dr. Sunil Aberatna, for highlighting the intricate web of challenges and opportunities which the regulators face in harnessing and the potential technology while safeguarding patient safety. It's open for discussion. If anybody has any questions, can ask. If not, can I ask Professor Anuja Fernando, how do economic pressures like and healthcare resource allocations, like in the third world settings where we had a lot of issues with resource allocations, and how can it create ethical challenges in clinicians and policy makers?
We have to, I suppose, manage with what you have, and what we are actually doing is getting the patient to spend sometimes in day. If we can't afford to spend for the drugs, if the government can't afford, we get the patient sometimes to buy various equipment or drugs. So I suppose right, if the patient can afford, but if not, we could have a sort of a fund. I think we have that also, President's Fund or something like that, where you can. Otherwise, there can be a problem. I mean, when you have to spend for, say, some rare diseases with the expensive drugs, that's sort of the time that you go to the President's Fund, I suppose. I think you can appeal for bonus also. That might be quite a lot of
can regulators balance the role of enforcers of standards while being perceived as partners in improving healthcare quality and safety?
How can we maintain standards while there's difficulty maintaining? Yeah. I mean, maintaining standards is. The standards are very broad, and we make sure that everybody has bought into them. That includes the profession and the public. All have been fully worked through, and we need to make sure that they're manageable. We've come back down to resources again here. Within every country there is a resource envelope through which healthcare can be delivered, and I think that we have to recognise that and understand that, not necessarily make allowances for it, but make sure that we recognise that when it comes to the compassionate way in which we deal with the public and the profession who we're regulating.
Dr. Sunil, should there be a one-size-fits-all approach to regulating health technology, or there should be a regulation which is risk-based, adapted, or to a specific technology?
Technology is always different. There is no doubt. Today's technology is not technology tomorrow. We are living in such a environment. So therefore, that introducing the proper regulations doesn't mean that regulators want to restrict our professional life. These regulations are there to build up goodwill between patients and medical professionals. So therefore, when we follow these regulations, we can see the risk-free, we can carry risk-free profession. It is important. These regulations are there to safeguard this profession without any delay. This is what we can see. There is a delay of introducing regulations not only in the medical sector, but other sectors also same, even in my sector as well. So therefore, it's a time to introduce the required regulation without any delay to face the tomorrow.
Just final one, I think, before we wind up. So, what do you think about the Online Safety Act? Is it too harsh on the people who are implementing?
The problem is we drafted this Online Safety Act following some piece of legislation available in European countries. First of all, you must understand socio-economic, cultural and political situation is quite different in Sri Lanka to European Union countries. We can't just bring a carbon copy of this act to Sri Lanka. We have to adjust everything according to our cultural and social issues. Online Safety Act is good. The reason is we are using all devices. We bring these devices from other countries. In Sri Lanka, we only assemble. We are not manufacturing. And we use internet. What is internet? We don't use the Sri Lankan internet, or we don't use Indian internet or Pakistan internet. The internet is internet. If we use this common internet and if we use common device, why can't we follow the legal process in other countries? The issue was drafting of this act. Even I am the chairman of ICT Lawyers Guild of Sri Lanka. We also filed a case against Online Safety Bill. We challenged the appointment of commissioners. Earlier, commissioners were to appoint by His Excellency, and removal also from His Excellency. Only the commission can prosecute the case. Now you can understand biasness of this act. So after challenging the Supreme Court, change this provision. Now it must go before Constitutional Council. Problem is the people who come to positions, they must play neutral role. This is the attitude of people. It is not the fault of the act. So we have to go a long way. Considering new offences specified under third part of Online Safety Act, this is for the safety of the people in this country. If other countries can maintain the same offences, why can't Sri Lanka do it?
Thank you very much. I'd like to thank all the panelists for that discussion. Thank you very much.
And now I'd like to invite the moderator to present tokens of appreciation to our esteemed panelists. And it is my honor to invite the speakers to please come forward and graciously accept this token of our heartfelt appreciation. Professor Anoja Fernando. Abeyratna. Following this, I would like to invite Professor Manori Gamage, Dean of the Faculty of Medical Sciences, University of Sri Jayawardenepura, and Council Member of the Sri Lanka Medical Council, to kindly present a memento to the moderator, Dr. Suresh Shanmuganathan, as a gesture of gratitude for his leadership and moderation of this award discussion. Thank you to our distinguished dignitaries.